Okay, well, good evening, everyone. On this potentially stormy evening, we have Jon Sharp with us this evening, who's going to be talking to us about insurance and the JCT. And as always, please, if you could submit any questions for Jon via the Q&A facility in your bottom toolbar, and then at the end, Jon will endeavour to answer them for you in his own inimitable style. So without any further ado, Mr. Sharp, I will hand over to you. The floor is yours.
Good evening, ladies and gentlemen. Trust that you're all safe and well. I'm in Scotland and it's absolutely boiling hot here, so you'll forgive me, I've got the fan on. If there's any problems with hearing me, then please let Julie know and I'll try and speak a bit louder. Insurance and the JCT, I always feel that insurance under the JCT contracts often gets overlooked, yet it is of crucial importance. And therefore, I hope what I'm going to say is of use. I also have to give full credit to Phil Lamb of MPW Brokers, part of the Clear Insurance Group, who normally gives this talk with me. But unfortunately, he's not available at the moment. So I'm afraid I'll have to do the very best I can with his slides, but I must give him full credit for assisting with this presentation. That's me. Details are all at the firm's website. Less said about him, the better. Right, we're going to look at the three important principles of insurance, the reform of the Marine Insurance Act of 1906, Third-Party Rights Against Insurers Act 2010, a thing called CIDRA, Insurance Act of 2015, warranties and fraud, case studies, construction insurance, and top tips for getting your claim paid before going on to look at the specific clauses of the JCT contract as they relate to insurance. The reason we're going over this is it's important that you know what your obligations are under the terms of the now Insurance Act in relation to placing of insurances. So, three important principles. The first is, irrespective of changes in the law, insurance is a policy of indemnity. It's designed to put the insured back into the position they were before the insured event. Not better, not worse, the same. An insurance is a contract between the insured and the insurer. Therefore, the insurance policy's terms and conditions are important. Anyone trying to make a business interruption claim at the moment will know that by now. And so the insured's aim has to be to ensure it has full cover for any eventuality. Proper insurance, certainly in normal times at least, can save businesses. Just a little history. Insurance was basically governed by the 1906 Marine Insurance Act. It was a very clear and concise act, still is. And it served us well for well over 100 years, until the Law Commission decided that it was unclear, unfair, and a bit archaic. So rather than reforming something terribly useful, like the Consumer Credit Act, it decided that the Marine Insurance Act needed to be reformed. Why is insurance important in this country? Well, Lloyd's of London primarily, it's still the third largest insurance market in the world, and I'm not quite sure how many billions of unearned income it makes. So to replace the Marine Insurance Act 1906, three new acts were passed. The Consumer Insurance Disclosure and Regulations Act 2012, or CIDA as we call it in the trade, CIDRA as we call it in the trade. The Third Parties Rights Against Insurance Act of 2010, which was enacted in 2016, and the Insurance Act of 2015, and I will mention at the end the Enterprise Act. We don't need to be too concerned with CIDRA. Well, for these purposes, I'm assuming that I'm talking primarily to companies rather than individuals, but it applies to consumer insurance contracts. So that's individuals who buy motor, house contents, personal home insurance, etc. Yeah? The Insurance Act of 2015, introduced in 2016, applies to all commercial insurance policies commencing on or after the 12th of August 2016. It introduced a new duty for all non-consumer insureds to make a fair presentation of the risk. It also reduced the insurer's remedies for breach of the duties of fair presentation. So when you're placing a contract of insurance, what do you need to do? Well, it's your duty now to provide all relevant information. And you must now involve all relevant senior management when compiling the information for insurers. So you've not only got to state material circumstances that you know, but also those you ought to have known about, bearing in mind the nature of your business after you have conducted a reasonable search. And you must provide that information to the insurer in a reasonably clear and accessible manner. Fair presentation of the risk, a little bit more detail on that. Senior management, well, it's anyone that has a key role in making decisions on behalf of the company. Now, this need not just be the directors of the company. It could be operation managers, site managers, anyone who has a direct say in how the company operates, how parts of the company operate in an insurance framework. Material circumstances, well, that's anything that would influence the judgment of a prudent insurer when he decides whether to accept the risk, and if so, on what terms. Prudent insurer, well, that's someone who's a safe pair of hands, for want of a better description. There have been one or two insurers and particular underwriters at Lloyd's who've had a more flamboyant approach to writing insurance risks. But this basically means your normal standard underwriter who is reviewing a risk using common sense, I suppose, is a good way to put it. Known or ought to have known, basically commonly available information that affects your business, i.e., for example, in construction, you're expected to be informing insurers that there are new building regulations coming into force during the period of the insurance policy. Reasonable search for information, well, that depends on the nature of your business, the type of insurance you wish to buy, but you need to do a good, have a good comprehensive look at the people within your business that can usefully provide information to insurers. When it says reasonably clear and accessible, I've said not in a carrier bag. So no, you wouldn't just dump it all on the insurer's desk and say, there you go, there's my disclosure. But put it in an orderly fashion. But also don't hide key facts amongst large amounts of wholly irrelevant material. If you're placing a construction policy, it's very unlikely that the insurer is going to be in the slightest bit interested about how many days off sick your staff have had during the course of the year. The Insurance Act 2015 was supposed to balance up the playing field between insurers who used, I don't want to use the word excuse, who relied on the policy wording too much to avoid risks. A classic example of that is certainly before the Insurance Act 2015, if your warehouse flooded and there was a warranty and you'd warranted to insurers that your fire alarm worked, insurers could avoid the flood damage by saying, well, your fire alarm didn't work. That's now changed under this Insurance Act because the courts would regard the fact that the fire alarm didn't work as wholly irrelevant to the loss. However, you mustn't be deliberate or reckless. So if you just fail to disclose the fact to insurers that actually half of your construction business does some manufacturing as well, well, they can avoid the policy and keep the premium. If you fail to disclose something to insurers that really they wouldn't have liked at all and wouldn't have written the risk, well, they can avoid the policy, but they have to return the premium. In respect now of just about all other breaches, if the insurer, when he wrote the risk, would have imposed additional terms, they're imposed from inception of the risk, or if a higher premium was to be charged, then the claim is reduced by the amount of the additional premium that would have been charged. You've got to remember that the Insurance Act 2015 is a default scheme. Insurers can contract out of it, though they're extremely unlikely to do so. And if they do, they must tell you if a term is very disadvantageous to you. So they've got to bring it to your attention and ensure that the term that they're going to rely on is clear and unambiguous. I put a line in there about reinsurance contracts, but for all intents and purposes, I'm not going to go into reinsurance and how that works, I'm afraid. Time doesn't allow, but happy to answer any questions on it. Now, what else should you consider taking? Now we've established the principles of how you place your insurance policy and what your obligations are. Let's have a look at what else you might consider taking out under JCT if you are in the construction industry. Well, directors and officers policy. This covers the directors of your company for normally personal liability in the event of, say, a corporate manslaughter situation. It doesn't obviously pay any fines imposed on the company, but it will pay the legal costs of defending a case brought against you. Seriously worth thinking about if you're operating large companies. Get some protection from your directors and officers. Cyber attack policies. We all hold confidential information. There is competition within the construction industry. You want to make sure that you have a good cyber policy that prevents or certainly assists you in the event that you have a cyber attack. In the last, well, since lockdown took place, insurers are reporting who write that type of business a 40% increase in cyber attacks. You might want to think about key man insurance. So in particular, insuring an individual who may be absolutely crucial to the work on a major project that you're having, the individual that you're working on. If that individual has to travel abroad, you need to have him protected, and the key man policy does that. Pollution, need to have a think about that. Public liability policies, they normally only cover one event, and it has to be sudden and accidental. Contractors' all risk policies, some policies cover cleanup costs up to $1 million. You can buy site-specific pollution. It is expensive, but seriously think about it. If you have a site that was contaminated, why wouldn't you at least consider it? Professional indemnity, of course, you have a duty of care to others, and also it tends to avoid the issue of whose design error it was, subject to what I'm going to say a little later on. So the conclusion of this part is this: make sure you comply with your disclosure obligations. You cannot supply your insurer with too much relevant information. If you fail to disclose, it has consequences and will cause you difficulties. Mind your excesses. Normally, if you have an excess on your insurance policy, it will reduce the amount of your premium. But think about it. How much can the company realistically afford to bear? And also remember, if you have multiple incidents, that excess may apply to each incident that you have had. Ted Baker found this out in a case called Ted Baker and AXA. Ted Baker sued their insurers because they said that the clothes stolen from their factories was not covered under the policy, even though it was a theft policy. Now, Ted Baker won, and insurers had to pay, but they had so many excesses which applied to each and every taking of the clothing that eventually they ended up with nothing. Read your policy wording. I'll come on to that in a second. Also, regard your insurance policy as a living document. Do not, when you receive it, simply put it in a box, put it in a drawer and forget about it for the rest of the year. Nah. You will, during the course of a year, maybe doing different types of work. You may take on an unusual construction project, something that you're not necessarily used to. Now, you may well think, well, I'm covered. Well, are you? The best advice is to notify your insurers if you're doing something slightly different. You may well be covered. But if you don't tell them, something goes wrong, they may well turn around and say, well, actually, you weren't covered for that. Beware the loss adjuster. In construction contracts, virtually always a loss adjuster is appointed. He is the insurer's friend. His job is to reduce the amount of the claim as much as he possibly can. So when he arrives, make sure, for example, if your warehouse has been flooded, that you haven't left all the boxes floating in the water. Remove everything, make it look as if you've done the best you possibly can to reduce your loss. That will put you in the loss adjuster's good books. Remember, until any cover that you take out is confirmed, you've got to act as a prudent uninsured, so behave sensibly. And that's the same with a claim. Until such time as insurers say your claim is covered, you have to do your very best to minimize the losses resulting from the claim. One small caveat to that, that's the effect of the Enterprise Act. There are so far no cases, but this little section in the Enterprise Act has now been put into the Insurance Act of 2015. I believe it's clause section 12A, but don't quote me. What that says, and this is interesting, if an insurer unreasonably delays in paying a legitimate claim, so say 6 months or more, then you can now get damages against that insurer. Now, as I said, at the moment, I'm not aware of any cases, but remember that it's there. So it's the first time that insurers have a duty imposed upon them by statute to deal with claims promptly if they're covered. So remember that in there. Now, you're probably thinking, what on earth is John doing here? Well, I'm trying to demonstrate the difference between what is called, in this case, a renewal schedule, but you can call it a cover note, a synopsis of cover, a summary of cover, etc. This is what you are normally sent by your insurance company, by your broker or your insurance company when you renew. But this is just a summary. It's a schedule of what you're covered for and what you're not covered for. So in this particular case, you'll see on section 8, contractors all risks is included in this policy. Annual contract value in total for all contracts. You're covered for all the contracts you do for 2.5 million. Maximum current value any one contract, 30,000. Not a lot, really, is it? Contracts works insured, 30,000. It's not going to get you very far, that is it. But you'll see that it's only a 3 or 4 page document. That one is 12 pages long, so I've just given you the first 4. That is not your contract with your insurance company. It is not. This document is. This is your policy wording. These are all the terms and conditions that you have with your insurance company. As said, it is a long document. You can see that by its contents page. 64 pages this document runs to, and this is your contract with your insurer. Your previous document, call it what you will, summary of cover, etc., is not. This is the document that the courts rely on when interpreting a contract of insurance. in a case called Kuwait Airways and Kuwait Insurance Company in 1990, the policy wording for the year in question, so the year when Kuwait Airways lost their fleet as a result of the invasion of Iraq by Kuwait by Saddam Hussein, had not been agreed. But such is the importance that the courts placed on policy wording that it looked at the previous year's policy wording to interpret the new year's policy. So this is your crucial document. This is what you should be reading, checking to make sure it covers you for what you want cover for. I'll move now on to more specific issues with the JCT contract and insurance. As said, this was, I was very greatly assisted by Phil Lamb of MPW Brokers. There's his details. The only thing I would say is that Phil says that he plays golf. Well, I've seen Phil play golf, and play is used very flexibly, is all I can say. Right, we're going to have a look at introduction. We'll quickly look at the JCT contract suite. Design and build contracts 2016. We're going to concentrate on that contract. Look at the indemnity and insurance provisions. We'll look at potential concerns. And then there's Phil's contacts, and I'll take some questions at the end. JCT has been the main form of contract for general construction for many years, at least 50. It's recognised as the standard contract. There is, of course, now NEC 4. That's a recent alternative, but JCT contracts are improving all the time. Well, I particularly like the JCT Constructing Excellence contract. I think that's very good. But of course, there are some other contract forms for specific areas of construction, such as civil engineering, mechanical engineering, etc. But without a shadow of a doubt, JCT still rules the roost. However, one of the criticisms of the JCT suite is that there is a vast array of contract forms, subcontract forms, and warranties, making them a very complicated suite of contractual documentation. We're going to focus on the main form we encounter most, which is JCT Design and Build Form 2016. As Phil rightly says, contract forms are very often amended. And can I please make a plea to everyone from the construction industry here? When you're amending your JCT contracts, please, 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 can you write clearly, preferably tightly amendments, and add them as an appendix? Could you please then get both parties to sign it? It would make my life, and indeed many other lawyers' lives, a great deal easier. But we're going to look now at we're going to work on the basis of the standard provisions. Right, these are based upon the employer's requirement. The standard JCT 2016 Design and Build is based upon employer's requirements and the contractor's proposal. There's a fixed point of responsibility for construction and design issues. Neither the contract sum or the period can be varied unless employer's requirements are amended, and therefore it is a popular procurement method for these reasons. Everyone's familiar with it, everyone's used it a lot, and therefore it has gained considerable popularity. The contractor's design indemnity is set out in clause 2.17. Where the design is comprised in the employer's requirement, the contractor's proposal, the contractor is responsible for any inadequacy in the design. They have the same duty of care as an architect or other professional. That's the contractor. Under clause 2.71, contractors must supply all relevant design documents for retention and use by the employer. The contractor is responsible for any inadequacy in the design. It isn't right, ladies and gentlemen, I think it's fair to say. A contractor provides labour, he provides plant, he provides materials, he builds things, he doesn't design things. yet he's responsible for any inadequacy in the design. And this will include designs carried out on behalf of the contractor that form part of the contractor's proposals. That's not quite so unfair. If a contractor employs an architect who produces designs, then it's reasonable, I suppose, for the employer to say, well, you employed this guy, it's gone horribly wrong, you're responsible for his work. And this, of course, can include any design works carried out by consultants on behalf of the employer that are then novated into the contract. So in some circumstances, the contractor hasn't even employed the guy, and yet he becomes liable for their work. Any claim for a possible design defect then will land at the contractor's door, and his insurers will have to defend any claim with the attendant costs. Of course, there might be a route of recovery for the insurance company if negligence can be proven on the part of any consultant providing a design function. But that's costly, it's expensive, and not always easy to prove. Contractor's obligation to ensure professional indemnity, to acquire professional indemnity insurance, is set out in clause 6.15. Contractors must effect cover for the sum limit stated in the contract particulars, and that must be maintained for the period stipulated in the contract particulars. And he's got to provide evidence that he's got such insurance in place. Now, you're the contract administrator, what are you going to be happy with? Are you going to be happy with the summary of cover document that I showed you earlier? Are you? The answer is probably not really. You should be wanting to see the policy wording. Because although the summary of cover may well say they're covered for £10 million, in the policy wording, it may say you're covered for £10 million provided that. And there may be a whole list of exclusions which may invalidate any potential claim. So see the policy wording rather than the summary of cover. The contractor is required to effect cover provided it is available at commercially reasonable rates. That's in the JCT contract. I'll come on to that later, as professional indemnity insurance at the moment is exceptionally difficult to find. If you can't find it, then the contractor must notify the employer, and if possible, you need to try and find a resolution to the matter. Though for the life of me, I'm not sure quite what that would be. There are other provisions set out in Section 6, injury, damage, and personal injury insurance. Contractors' liability 6.1, you've got to take it out for personal injury or death, employers and public liability arising out of the works. Clause 6.2, contractors' liability, loss, injury, or damage to property excludes the works and existing structures, public liability. Okay. Clause 6.3, loss or damage to existing structures. Existing structures and their contents do not count as property pursuant to clause 6.2. Similarly, the works do not count as property pursuant to clause 6.2. So that property is at the risk of the employer. Insurance against personal injury and property damage is normally in your contractor's insurance. Clause 6.4, contractor must insure for the statutory required limit for employer's liability. This is not an either or, you have to have it. For any other claims of third-party injury or property damage, the minimum indemnity limit required will be set out in the contract particulars. Again, you need to take care when arranging employer's liability insurance. You will need potentially to add to that if the contract requires it. Clause 6.51, contractor's insurance of the liability of the employer. Contract particulars will set out if this cover is required. Where the works are close to or on a shared wall with a neighbouring property, it's very likely to be recommended. Covers the employer's legal liability, not the contractor's. Cover typically covers any expense, liability, loss claim, or proceedings that the employer may incur or sustain by reason of injury or damage to any property caused by collapse, subsidence, heave, vibration, weakening or removal of support or lowering of groundwater, arising out of the carrying out of the works. Obviously, you're not going to get that cover and then something just falls down. It has to be caused by the carrying out of the works. Cover will specifically exclude any negligent act of the contractor. Now, potentially you might get some cover under public liability, but negligence by the contractor is almost always specifically excluded. Errors or omissions in design, inevitable damage. That's a slightly tricky concept. You'd have to show that the damage that was caused would have happened in any event. Not going to be easy. That which the employer must insure under clause 6.7c, works or site materials, and war, riot, insurrection, civil commotion, etc. are always excluded as well. Oh, sorry, pollution and contamination is also excluded, and damages in respect of any breach of contract. So if you are trying to arrange your insurances to comply with the JCT contract, you need to get quotes that are on a project-specific basis. So you need to be liaising with your broker, saying, right, I'm just about to enter into this contract. This is what I've got to cover. Here is the contract. Can you make sure I'm covered for it? Okay. Ideally, it should be placed with the contractor's public liability insurer, which will avoid disputes over negligence. Clause 6.7, insurance of the works on existing structures. Insurance options you get are options A, B, and C. There is a D and E, but they're hardly ever used now. They're set out in Schedule 3 to the contract. In each case, the policy must be in joint names of the employer and the contractor. And in each case, the policy must be maintained until practical completion, evidenced by the appropriate certificate. Clause 6.7a, new build, with the contractor to insure works on an all-risk basis. Clause 6.7b, new build, with the employer to insure works for all risks. Make sure you get the right one. Clause 6.7c, sorry, 6.7.c, works involving alteration, repair, extension, renovation, alteration, maintenance, or repair of an existing property being worked on. So I said there is a D&E, but they're hardly ever used now. Make sure when you're placing contractors all risk that you get the right one. Clause 6.7c1, employer to insure existing buildings and contents for loss or damage arising from one of the specified perils. Clause 6.7c2, employer should insure works for all risks. Now, you should include terrorism cover. I know that we are living at the moment in a more relatively peaceful world. Certainly, if you're conducting any form of construction project within a major conurbation, then you must consider terrorist cover. It's frankly reasonably cheap, so it's not really worth the risk of trying to exclude it. Watch out where the employer under contract does not actually own the building being worked on. Make sure you know who owns the building you're working on. Are they a tenant? In which case that causes a great deal of difficulty. Whichever clause applies, subcontractors on site have some automatic benefit to certain cover protection. under the joint names policy. A waiver of subrogation rights or recognition as insured for damage arising out of specified perils until the subcontract works are practically complete. This re-emphasises the point there that the subcontractors may well be covered until practical completion. But that does not mean that subcontractors have no responsibility. They do, and subcontractors should always take out their own insurance policy. There was a case called Haberdashers Ask, I think, where the building caught fire, and it was basically an argument between the two insurers. The subcontractor had caused the fire, but he said, I can rely on the contractor's and employer's policy of insurance, even though I've got my own. And they said, no, you can't. You've got your own insurance policy. You've got to rely on that. And the courts eventually decided that the subcontractor's insurance policy was the one that would respond to the damage. Potential concerns, well, employers and public liability insurance, as we've just discussed, the joint names insurance, that causes potential difficulties, and professional indemnity insurance. So let's look at these concerns, employers and public liability insurance. Well, the JCT contract is not particularly prescriptive. It doesn't really go into that much detail about what you've got to be covered for. Policy wordings that are taken out are many and varied. Those of you that are familiar with the recent business interruption cases, I must have considered at least 7 myself, and no 2 are the same. And in fact, there are some 78 different types of business interruption wording. And it's the same with employers' public liability insurance. That's why I've stressed earlier, check your policy wording to make sure it covers what you want it to cover. Repeating that cover must remain in force during the obligation period on the contract. Cover must fully reflect the nature of the work to be undertaken. And there must be no type of work exclusion or limitation applicable. Again, you need to check your policy wordings. Some insurers will not cover particular types of work. So it may just be working at a height over 50 meters. They may say we don't cover that, ever, 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 ever. So you need to check your policy wording. I'm afraid saying you need to check your policy wording is unfortunately a bit of a catchphrase of mine that I accept entirely. It's not particularly catchy. Employers and public liability insurance, the nature and status and security rating of insurers vary. Make sure you've got a good insurer. Do not have an insurance company that is based in Gibraltar or overseas. It's exceptionally difficult to make any recovery from them, and they will likely be limited as to the amount of funds that they can pay out. Many offshore unrated insurers operate in the UK market. They do indeed. Check which insurer you've got. So you need to have someone in your company who's responsible for checking the ongoing adequacy of insurance. Or alternatively, you can rely on your broker, providing your broker is of good standing, and by that I mean it will be registered with the FCA. Joint names insurance, the obligations under clause 6.7c1 often cause problems. The employer under the contract might not be able to comply with specific insurance obligations. He might not own or insure the building. He's a tenant or a leaseholder. It's the most common reason for these types of problems. The building might not be insured but protected under a risk protection agreement or captive insurance program. The existing builder's owner, the landlord, or their insurers might simply refuse to grant the necessary joint names insurance provisions. They can do that. There might be other occupants of the buildings who have no interest at all in the contract. Joint names insurance has a footnote within the JCT contract that recommends an alternative insurance schedule, CI, is drawn up by an insurance professional. Now, clearly, Phil was very excited about that and agreed with it, but I would as well. Professional indemnity insurance, the market for design and build professional indemnity insurance is very, very, very difficult. I'll tell you why. In 2002 and 2003, there was a spike in professional indemnity premium. Two things caused higher premiums. The first is what's called a lack of capacity. So basically, that's what it says. There aren't enough insurers to write all the business that's out there. Now, that wasn't the case in 2002, 2003. It was the second cause, which is major market-wide claims. So not just one sector is affected of the insurance market, but a wide range. In 2002, 2003, we had the tragic events of 9/11, and we also had most of Europe being flooded. It was the worst floods in some cases for over 100 years. In some countries, it was a once-in-a-lifetime event. Those two factors combined for about 18 months to raise professional indemnity insurance premiums. Now, in 2018, Lloyd's of London conducted a survey of its insurers and basically said to some of its insurers, you are writing this risk at too low a premium. If there is a major claim, we will not have enough money to pay the claims. The response of most insurers was actually to say, okay, we'll stop writing it then. So they pulled out the market, you had a lack of capacity. You then had the tragic event at Grenfell. They're still being litigated, but there are huge professional indemnity claims there. In addition, there's an aeroplane called the 737 MAX, which I think most of you will know has now been more or less withdrawn from the market because, frankly, it just didn't fly. And as a result of that, Boeing have huge insurance limits. All of these have also impacted across the insurance market. So professional indemnity insurance is exceptionally expensive, very hard to get. Market capacity is reduced. Aggregate limits are being imposed. So instead of having 10 million cover each and every event, it's now 10 million cover, that's your lot. And there's now a huge range of combustibility exclusions for cladding, etc., being imposed. To some extent, to be expected. In extreme cases, a total exclusion relating to combustibility of the entire building envelope is being applied. Claims are generally being very strenuously refuted, and insurers are reluctant to grant indemnity. The default position, of course, is that you're not covered, but then you can't enter into JCT contracts. So it's a bit of a conundrum. I have certainly heard stories within the insurance market of premiums for one particular client. His premium in 2016 was £100,000, now being charged £750,000 for a reduction in cover as well. The contractor is also placed in an extremely difficult position, as we've just discussed. He might be in breach of contract as well, because if he can't arrange the insurance, he's in breach of contract. Any warranty granted might be affected, and documentation in relation to contractual obligations, if it's executed under deeds, can last 12 years. So he can't get a professional indemnity insurance. He must be advising the contracting parties that he can't get it. To summarise then, it is going to be for professional indemnity insurance an exceptionally tough year. You have to have it under the JCT contract. You may be paying a huge amount of money for it, and insurers at the moment are fighting claims tooth and nail. So it is not going to be an easy time to obtain professional indemnity insurance. I cannot think of any other way around it. Perhaps deeds and bonds might come in, but it's going to be very increasingly difficult to obtain it, and the premiums that are going to be paid for it will be enormous. So I'm afraid to say it's a difficult time. And how long will it stay a difficult time for? Well, if all the claims in relation to COVID-19 come in, which will also be seen as a market-wide loss, especially on business interruption claims, then I cannot see the market returning to any form of, well, competitive tendering professional indemnity work for at least the next 4 to 5 years. I hope I'm wrong. I think it's going to be that level of time before we see anything like premiums coming back to the level that they were before, if in fact they ever do. So, ladies and gentlemen, any questions? I'd be delighted to take them. Hello, Julie.
John, thank you for that.
Did I wake you up there, Julie, slightly?
Say again?
Did I wake you up slightly there, Julie?
Not at all. I'm sitting and waiting in anticipation for this particular segment of the seminar, John. We've got someone who's asked here, as you mentioned the haberdashers case, why do lawyers, when drafting the JCT contract, not amend the insurance requirements correctly for project policies to create express conditions?
Well, I can't speak for other lawyers, but this lawyer does. I don't know. I think this is a very broad generalization. I don't think construction lawyers always look at the insurance position. I don't quite understand why, because it is absolutely crucial. You have to have a good knowledge of insurance to be able to understand and interpret properly a construction contract. Again, I tend to think that they simply say, well, have you got insurance cover? Here it is. Okay, that looks all right to me. Well, it's not. It's actually a much more complicated area than people recognize, and certainly I think construction lawyers in general do. We have an insurance expert, and well, it's me, and I regularly look at insurance contracts and policies for contractors in all sorts of different scenarios. So I'm afraid this one does. I suspect you're right that many don't.
Okay, and we had a couple of questions pre-asked as well prior to today. What advice should contract administrators be providing to flat or building owners preparing to undertake construction work?
Julie, can you just repeat the question? Sorry, darling.
Yes, certainly. What advice should contract administrators be providing to flat or building owners preparing to undertake construction work?
Well, good question. I always think the contract administrator is in very, very difficult, is in a very difficult position, especially when it comes to insurance. I think, as I said earlier, that in relation to checking whether contractors have insurance and whether it's adequate insurance, that is always a tricky job for a contract administrator. What he needs to do is make sure that the contractor's insurance policy does contain provision that covers flat owners, etc. Now, he can only do that by seeing the policy wording. But I've spoken to one or two contract administrators who've repeatedly said to me that they do ask for it, but they never get given it. So it's a very tricky situation for them. All I can suggest is that they find out as much about the insurance policy as is physically possible, and preferably see the policy to ensure that occupiers of flats, etc., are properly and adequately covered.
Okay, someone else here is saying, when it states unlimited liability, but it is not practical to get that type of policy, what is the best course of action? As a contract admin, it usually falls to accept whatever the contractor has, regardless of project size.
And I agree, and I don't think it's terribly satisfactory, but I'm afraid, given that obtaining professional indemnity insurance now is so costly, but I think contractors are scrabbling around for really what they can get at a halfway reasonable price. If they can't get it, and there is provision in the JCT terms to say that it has to be reasonably affordable effectively, I really am struggling to find out what the alternative, to think of what the alternative could possibly be. Maybe deeds, maybe bonds are the answer, but even they're increasing in price now. So it really is a very, very difficult situation that we've all found ourselves in now as a result of the lack of capacity, Grenfell, 737 MAX, and potentially now COVID-19. Professional indemnity premiums are not going to go down. The only place they're going to go is up.
Right. Okay. Someone else is also referencing minor works, clause 5.4c and IFC, clause 6.7. What documentation should be obtained? What wording could be added into the contract under 5.c, insurance arrangements? Details of the required policy or policies are set out in the following documents, that kind of thing?
Yes, it is really that kind of thing. You need to, again, it really comes down to this. There should be some, and it doesn't happen very often, there should be some better transparency or maybe amendment to the JCT contract at the time of signing to say it's a condition precedent to signing this contract, that the policy wording and the policy is exhibited to this contract. The moment, it doesn't seem to, first of all, get the focus it deserves. Secondly, there is a tendency to try and avoid disclosing exactly what cover you've got. You may have a policy that looks on the face of it like it's got a very high limit. In fact, it could be riddled with exclusion clauses, which make it virtually worthless. So all I can say is you need to do the very best you can to get hold of the relevant insurance policies and see what is actually covered by them.
Okay. Someone's saying here, would the contract administrator be liable for not pointing out to the employer that they have taken out a joint names policy in the case of option C?
Very possibly. Very possibly. As I said, I feel very sorry for contract administrators at the moment. There will be I can see an increase in reluctance to provide full details of insurances, etc., etc., etc. And certainly the JCT has to be a joint names policy. There's no way around it.
Okay.
But I have also spoken to some contract administrators who say they never even ask for the insurance policies, and that's plainly wrong. And I think would be found so without hesitation by the court.
Right. Someone else is stating here that why the JCT contract amendment's getting longer all the time. They've had one recently that was 150 pages.
Honestly, well, I think honestly it's because the JCT 2016 one is now getting slightly outdated. It is time for an upgrade to take into account, well, if nothing else, it'd be nice to have a force majeure clause in there. So it's getting longer as case law basically changes the law. JCT contract hasn't kept up. Therefore, you're getting longer and longer and longer amendments, etc. It's also due to the fact that we have some lawyers, not this one, but some lawyers rely very heavily on precedent. And if the precedent says it should go in, they put it in.
Right.
So that's why it goes in. Now, the problem with doing that is eventually you get clauses which, when read together, make absolutely no sense. But because the precedent book, this is how commercial lawyers work, said it should be in, it has to go in. So that's why, in a nutshell, it's getting longer. But it's really, the main reason is the JCT 2016, it needs an upgrade, it needs rewording now, it needs looking at again, it needs to be reprinted, I suspect.
150 pages does sound spectacularly painful, though.
Yeah, but that's commercial lawyers for you, see.
Okay. That is the end of the questions. So thank you very much, John, for sharing your time and your expertise with us. We look forward to seeing you online again soon. I'm sure there'll be an insurance COVID-19 update before too much longer with one of your talking head stops. Everyone else, thank you very much for joining us this evening. We have got other dates available with lots of other stuff going on for June and July, so make sure you have a look at the website and book yourselves in. Other than that, will everyone please stay safe, and we hope to see you again online soon. Thank you, John, for your time.
Thank you, Julie. If anyone does have any more questions, they can always email me as always.
No problem at all. Thanks very much.
Thanks, Julie. I'm going to go now.
Take care. Bye-bye.
Bye-bye.